Hey, how's it going, everybody? I just wanted to pop in real quick, and I wanted to elaborate over something I said. If people remember from my not my last video, but one of my videos before me addressing, some issues I had with some people who were trolling me. I wanted to talk about why I'm telling you that consumer law is not for you. Okay. When I'm saying this, I'm not saying it in an instance that some elements of it isn't to protect your interests. When you really understand the power you have, it changes the dynamic of your knowledge in consumer law. So, what people think is a consumer law is to protect you as the consumer, and you're not understanding that there's a primary market and there's a secondary market. If you don't understand these things, you really don't understand what's going on. So you're not understanding on the secondary market that your interest is being traded. Okay. This is what gives you a claim. So in my video where did call mind your business, I told you that you had a primary interest because you had a primary interest to a proprietary interest. There we go. You had a proprietary interest to all trade sales in all securities. Well, we're going to go over what is a purchase money security interest. Okay. A purchase money security interest, PMSI, arises in situations where the secured party provides the funds necessary to purchase the subject collateral. This can arise through a loan for identified collateral or when the secured party sells and then finances the collateral for the purchaser. So when a bank takes over a so-called loan, what is happening is they're doing a swap. So if you look into one of my in a video that I did, I put in the comment section what is called conversion. So if you understand what conversion is, it's basically somebody using property or using something that's not theirs in their interest. No one ever raises this. Fraudulent conversion. Okay. So when somebody conveys property where they legally don't own it, because you can't sell property that you don't own. That's why there's no such thing as an auto loan. I don't need to go through the complexities of the document because I understand what a transaction is. See how basic I can take it back to understand how a whole thing works. There is no such thing as an auto loan. Okay. There's no such thing as a mortgage loan. You're mortgaging, you're putting up the mortgage as a security. And you're collateralizing that against and transferring your interest to the so-called pretender lender who becomes a secure party because what took place was a sale, but you were not aware of the sale. You thought you were buying a house, but not knowing that you were buying an interest into a purchase, a security, which is going to be sold over the secondary market. And the reason why you didn't know that is because of they didn't disclose it to you, which means that it was fraud. Okay. So whenever you're subject to a contract that you have not signed that exceeds $500, it's under the statute of frauds. So they don't tell you about this when you go buy a car, which voids the initial installment agreement because it's subject to things outside of the document under the four corners rule. Okay, you can't take a document and then take 10 other documents beside that document and have these documents as security interests, and then all of a sudden you try to foreclose or do a forfeiture on the subsequent documents. You can only do the forfeiture on the document that contains the collateral, but they don't do that. That's why they create other securities for you, so you could be compensated because the Constitution says that no property shall be taken without just due compensation. Okay, so a PMSI is automatically perfected when the security agreement attaches to the collateral that is consumer goods. Consumer goods are primarily for personal use by the purchaser rather than for business use or resale. Note, consumer goods do not include vehicles subject to certificate of title or fixtures. Hint, hint. So consumer goods don't include vehicles, and they're not just talking about cars. They're talking about deed of trust. They're talking about automobiles. See, they're not talking about they're not talking about the physical goods. They're talking about they're talking about the paper. Okay, and then they'll give an example. Example: I purchased a refrigerator from Appliance World for my personal use. Appliance World finances the purchase by allowing me to pay over the next 12 months. We undertake the steps necessary for the security interest to attach. Appliance World has automatically perfected security interest in the refrigerator. Okay, an automatically perfected PMSI in consumer goods is subject to certain exceptions. These exceptions allow subsequent purchasers of the collateral to take the collateral free of the secure party's security interest. Okay? The purchaser of the consumer goods from the seller will take free and clear if all of the following conditions are met. No knowledge of a security interest. The buyer cannot know about the security interest in the collateral. Okay? Let me say that again. The buyer, this is talking about the secondary market, not the primary market that you're dealing in. So if you listen to what I'm telling you basically how to take over your accounts. So if there is knowledge that there is a security interest into the proceeds or the goods, they can't be sold into the secondary market. So when you're doing transactions, you're thinking, I'm paying down my mortgage. I've seen this in people's comment sections when you'll sit there and tell people like, you don't owe any bills. There's no bills. You're basically dealing in securities and trading things. You'll always see this dumbass that comes in the comment section. Just pay your bills. You should pay your bills, and you're supposed to pay your mortgage and pay for this. They're not understanding that every payment they make goes into the secondary market and does not go into the primary market. So in the primary market, what they do is they do a what is called a bookkeeping entry. So when you pay them, they could take your checks, they could take your drafts, they could take your ACHs, your ETFs, and then they could transfer that in the secondary market because you never secured your interest in the account. I hope you understand what I am saying. So you're agreeing to be a slave. And people don't get it. That's why your ACH payments they bounce. This is why. And even if they bounce, you paid it and you don't even know it. Okay. So that means that the security interest is not filed in an appropriate public office. The secured party is not perfected by possession, and the purchaser has not been given notice of the security interest. So look, the purchaser the purchaser has not been giving notice of the security interest. So the buyer must provide value for goods. Not the seller, the buyer. Listen to what I'm telling you. This means that the debtor cannot give me the goods as a gift. If I do not provide value, money, or goods in exchange for the goods are still subject to the secured party's security interest. Personal use must primarily use the goods for personal, family, household purposes. So the seller debtor must have originally purchased. See, they say seller slash debtor. Okay, remember, if you get a car loan, right? So the original seller purchased it for a business purpose and they're selling it for a business purpose. Listen to what I'm telling you. This means that they do not have a security interest because it says that this has to be sold what? Must primarily use goods for personal, family, household purposes. So, if somebody takes a business transaction, sells it for a business transaction, how can they have a secured interest? Interesting, huh? So, the seller debtor must have originally purchased goods for personal use, and the subsequent purchase must use the goods for personal use. If either party purchases the goods for business, it will destroy the exemption. What? That means that none of the security interests on your accounts are perfected. I hope you understand what I'm saying to you because they're not exempt. That means they can be attacked. Now, I want you to understand what I'm trying to tell you. I want you to understand what I'm trying to tell you. Okay, let's see. I'm trying to get this over here for you. All right. So, if you remember in my video, I told you that consumer law is not, it really doesn't have anything to do with you. In a way, what it's doing is protecting the secondary markets from your interests. So, a lot of times when these securities are traded in the secondary market, there's not a good amount of disclosure. So, if I bought, like, say, if I was a buyer of notes in securities. Once they sold off their once they sold off their portion of the pooling and servicing agreement, because you guys don't even know about pooling and servicing agreements. Um, Once they sell off the schedule in there, I can purchase the schedule, and when I buy the schedule, it may have a whole bunch of loans in that schedule. And these loans, I have no full disclosure on. So when I'm purchasing them, initially I'm taking it on face value that the buyer has followed the investor work rules. This is something else I know you guys don't know about. But I have a lot of knowledge about this because I was in banking and finance, meaning I was a foreclosure trial witness, so I know all of this stuff. The person who purchases this may not know that the buyer actually has an interest, or the so-called debtor has the interest in this or has not asserted their interest. Okay. This is why sometimes when you guys send in drafts, securities, or you send in promissory notes, whatever, when you send that in, if you don't know what you're doing, they're going to reject it. You could put 50 million UCC codes on it. It doesn't matter. Okay. Because you don't understand that there's a primary market and a secondary market. And there's a reason why they don't accept your remittance coupons, even though they legally have to. So we'll go into things like the Securities Act of 1933, the Securities and Exchange Act of 1934, the Trust Indenture Act of 1939. So I'm not going to do that on this call, but I'm giving you these because you need to read all of this. Now, when you go into Title 15, what happens is Title 15 is not for consumers as you think it is. Title 15 is to protect purchasers of chattel paper in the secondary market from consumers' claims. That's why there's a preservation of claims under 16433.2 CFR. This is to protect your interest into trading, or your security interest, or your proprietary interest into trading of chattel paper, because you're a trading merchant, but nobody ever disclosed to you that you're getting in an investment contract that is subject to other extension circumstances, not extension, extensive circumstances. You're subject to other agreements that you're not privy to. You have no knowledge. So when people are talking about consumer law, they don't understand that this has little to nothing to do with you. It's little to nothing. You have to read the Dodd-Frank Act. You have to read all of this to understand consumer law, not Title 15. Title 15 is just a chunk. That ain't nothing. So all these people tell you consumer laws and 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 stuff about all the financing charge and down payment is illegal and all this stuff. Yeah, down payments are illegal if it's not included in the finance charge. That don't mean down payments are illegal. If it's not reflected on the installment agreement, yeah, because what happens is it has nothing to do with you. It has to do with if that chattel paper is sold in the secondary market, there is fraudulent and deceptive methods. And if the primary interest holder commits fraud, it negates the secondary interest. Meaning that if you commit a primary, I mean, if you commit a what am I trying to say? I'm trying to phrase it very nicely. If you commit a primary, like, oh my goodness, if you do something in a primary, you can't collect on the secondary of it. Okay, so if the person who is trading, dealing in securities commits fraud, misrepresentation, or whatever, they can't collect on it. You see what I'm saying? So if anybody, it doesn't matter what company, if you commit fraud, you can't collect on it because of all of this stuff is traded on the secondary market. You see what I'm saying? All your receipts, your notes, your drafts, even if you're doing business with a small business, that receipt, that transaction is traded on the secondary market. So I hope this was very helpful to some of you guys that are trying to put some of this together. But you need to read things like the Securities Act of 1933, the Securities and Exchange Act of 1934. It'll give you a bigger perspective of what's going on, opposed to these smaller things that people are considered with. So you have to understand when you're bringing up claims that you're bringing up claims in the primary market to stop the the so-called financial institution from collecting in the secondary market, because that's how they're binding you. They're binding you because in the primary market, they saying that they're the secured party, they have a security interest into goods that are sold in the secondary market. This is why the courts don't let you get out of most of your contracts. So people are like, how come I'm losing in court? Because you don't understand that there's a secondary market and there's a primary market and there's a secondary market. And you don't understand what hypothecation is and rehypothecation is. But if you understand these things, you'll be a lot more successful. Well, I'm out. Y'all have a good one.